The data cell phone records do not disclose such communication between Ms. Kelly Khumalo and accused number 5 before this court. The SMSs between Ms. Kelly Khumalo and her sister Zandile Khumalo that reveal the following. In this regard, see page 6 to 12 of Exhibit 01. The trial commenced through the witnesses' evidence who were inside the house when the incident occurred, painting a picture of the robbery gone wrong. But when the trial progressed, it built around the assassination of the deceased. Brigadier Gininda described Ms. Kelly Khumalo as the mastermind and the trigger point in the execution of the deceased murder. And to that extent, he, Brigadier Gininda, applied for a warrant of arrest against Ms. Kelly Khumalo, which was never executed. As he says, it was a prosecutorial-driven investigation. I'm well aware, my lord, that the state is not bound by the summary of substantial facts, which means that the evidence in this regard still see State versus Van Vuren at page 21, paragraph D to F. The court will nevertheless, in the evaluation of the state case, compare the evidence given with what the state indicated its case will be. See State versus Holoko 1991, volume 2, SACR 203, capital letter A in bracket, at page 207, paragraph B to C. It follows that it is therefore crucial for the state case to indicate that the accused entered into an alleged conspiracy agreement with Ms. Kelly Khumalo. Failing such proof, the accused, that is accused number 4, cannot be convicted on any of the first 3 counts against him, and accordingly not on the 4th or 5th count.
La ngasho khona njalo kuphicelezi nodaba lokho lofakazi kade kuhamba letho umama lapho ke uPinki vithi high thing lathi khona ke njalo khona ke kade khona ke phecelezi nodaba lwezomthetho lapho ka section 204 kade khona ke lapho ke okungahambi kahle futhi amaphutha amaningi ke lapho ke phecelezi nodaba lakwamnumzana Colonel Steele umqhathanisa lona ke nodaba loqhamuka lapho ngaphansi ku Vodacom usho ukuthi uColonel Steele nako uqhamuka ngaphansi kwe database noma wasebenzisa lapho ke I database ezesiphoyisa ke ngesikhathi kade senza lokhu ke wacapha kuyona ke section 205 ke yakhe ke lapho ke bathi kokhona ke kwemibukiso lapho ke ka exhibit J1 futhi nalena kaPinki ke lapho ukuthi kade noma kade bengakhulumeli ke ngayo ke lapho ke la bathi khona ke kade ngakho ke ilukuzana data cell phone record lapho ke esho khona njalo kade khona ke inkulumo phakathi koKelly Khumalo ke lapho ke nomsola wesihlanu ke lapho ke athi futhi noma ngakho futhi idaba lama SMS ke lapho ke kade khona phakathi koKelly Khumalo nosisi wakhe lapho uZandi Khumalo oliqhamukile lapho ke futhi washo khona njalo kumele sibuke lapho ke ngaphansi kwesikhathi lesithupha kwesikhathi le12 ke lapho ke ngaphansi kwemibukiso ke lapho ke ka exhibit 01 lapho ke futhi ngesikhathi athi ngesikhathi icala leli ke noma ngesikhathi icala behlezi likhulunywa phambi kungasenkantolo lapho ke athi khona ke kwade khona ke abantu kade khona phakathi kwala music lapho ke futhi bona abantu bayisithombe ke khona ke lapho ke basho khona njalo ukuthi khona ke abantu kade befikile lapho ke bobamba ke inkunzi ke kepha kwakazi igcine kube sekubanjwa ke inkunzi ke lapho ke kepha gcina sebahlasela futhi bagcina ibulala ke khona ke lapho ke umufi ke lapho ke futhi athi uBrigadier Gininda naye uyena uchazile kabanzi lapho ke athi uKelly Khumalo uyena ke umastermind ukuthi yena ke umuntu odlala ke isikhangiso sokuthi lelokozana ke usuthi uyena kade ekhona phakathi nendawo ngesikhathi kade senzeka lokhu phakathi kwabasola futhi nomufi ke lapho ke bathi uBrigadier Gininda washo ukuthi kukhona ke incwadi kade icelile lapho ke noma isicelo sencwadi kade asenza lapho ke ukuthi lapho koKelly Khumalo nake aboshwe ke lapho ke kepha lokho bathi akaze kwenzeke ke ngoba impilo yakhe ukuthi lapho ke ngesikhathi bekasesha icala futhi bekasebenzisana ke nethimba labashushisi ke lapho ke futhi qhubeka washo khona njalo malana nesummary yakhe lapho ke ummeli wenu ke kade akhuluma ngalo yofakazi mhlawumbe ufakazi athi bukhona ke lapho ke wathi lokhu futhi yinto engekho futhi nanoma ekhuluma ngayo futhi ke wabuya futhi waqhathanisa phakathi kwecala leka Van Feren lapho ke ekhuluma ngaphansi komugqa wesi-21 noma ngaphansi kweclass wesi-21 eqala ku-paragraph D2F lapho ke akhulume khona njalo futhi nangelinye icala lombuso ngesikhathi umbuso ubhekene icala lakaHoloho lapho ke laka-1991 volume 2 CCR 203 lapho ke akhuluma futhi nangolunye ke udaba ke lapho ke futhi ubuyile wakhuluma khona njalo ukuthi lapho ke lokhu akukho la ithimba labashushisi noma ithimba lozombuso ke noma ihlangothi lozombuso la iqhamuke khona ke nenkulumo kade khona ke phakathi kwabantu labo ke futhi abasolwa ke lapho noma inkulumo eqhamukile ekusho ukuthi iyona ke vele ebambekayo nesihlahla futhi nomsindo ke lapho ke abathi ke laba bathi khona ke umsola abasola bonkana futhi noKhen Khumalo kade bekhuluma khona ke bonkana bephelele ke futhi asho khona nje umsola lapho ke akangabekwa ke amacala ngalokhu konke ke akwenzile ke noma lokhu abamthwesa ukuthi ukwenzile engakwenzanga futhi amacala wonkana omathathu futhi necala lesine futhi icala lesihlanu.
The legal position. I've referred to the provision of Section 174 of the Act. The corollary is that he ought to be acquitted. That is the accused, if it is reasonably possible true that he might be innocent. My own emphasis. The word no evidence in Section 174 of the Act means no evidence upon which a reasonable person might convict the accused, as stated by Ramsey J. Instead versus Kanyapa, 1979, Volume 1, SA 824, capital letter A in brackets, at page 834, paragraph F. It is well established that no evidence does not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. The question whether a court should grant a discharge at this stage is one which entails a discretion by the trial court. It is a discretion which must self-evidently be exercised judicially.
Ngaphansi kwezomthetho-ke lapho-ke la ekhuluma phecelezi nodaba luka-section 174 lapho isicelo lesathi aqhamuke ngaso-ke lapho-ke lathi khona ekugcineni kwecala lezombuso-ke lapho-ke kwamele ukuthi khona-ke njalo lapho-ke uma ngabe-ke abantu bebona ukuthi kanjalo abanalo icala phecelezi nabo kwamele balethe isicelo lesi-ke lapho-ke athi futhi kwamele ukuthi inkantolo ibabona bengenalo icala kwamele ukuthi badedele-ke ngoshwele-ke lapho noma ibadedele nje kuphela-ke lapho-ke wathi washo khona njalo lapho-ke nanoma kusho lokhu-ke athi ngaphansi kwezomthetho zika-section 174 lokhu akusho ukuthi ubufakazi bukhulu lapho-ke abukho-ke lapho-ke ubufakazi obukhethekile ubufakazi obubambekayo lapho-ke obungaze buphoqelele thizeni-ke abasolwa gcine lapho-ke bethweswa-ke icala-ke lapho-ke futhi beyaqhathanisa phakathi icala lapho lika-Ramf CJ futhi kade abhekene necala lozombuso-ke lapho-ke noma icala likaKhanyapa laka-1979 SA 824 lapho-ke A futhi washo khona njalo lapho-ke kwamele lokhu kubhekwe futhi kubhekisiswe kahle-ke lapho-ke uma ngabe ufakazi lokhu kade ufakazi obukhethe noma ufakazi ubambekayo obunesihlahla noma ufakazi obunomsindo lapho bungekho khona-ke kwamele ukuthi lapho inkosi yenkantolo mhlawumbe inkantolo lokho isebenze ngendlela ekhethekile futhi ngendlela ejulile lapho thizeni-ke idedele-ke abantu-ke lapho-ke kumacala ade bathwesa wona-ke.
The judicial pronouncement on the manner in which the trial court must exercise its discretion has been contentious. I do not intend to give a full historical overview. I will confine myself to a brief reference to those cases that help to define the scope of the court's discretion in terms of Section 174. In State versus Shopping and others, 1983, Volume 2, SA 119, capital letter B in bracket. The IMSTRA CJ reviewed the case law history of discharge application and formulated the test as follows at 120 to 121, capital letter A. And I quote, at the close of the state case when a discharge is considered, the first question is Roman figure 1. Is there evidence on which a reasonable person might convict? If not, Roman figure 2. Is there a reasonable possibility that the defense evidence might supplement the state case? If the answer to either question is yes, there should be no discharge and the accused should be placed on his defense, close quotation. There is criticism in respect of the second test in the Shopping case, and the criticism labeled was referred to in State versus Lubata 2001, Volume 2, SACR 702 SCA inter alia, as follows. At paragraph 14, the criticism of Shopping's case relates to the second leg of the inquiry, which permits an accused person to be placed on his defense, even when there is no case to answer, merely in the expectation that the defense evidence might supplement the prosecution's case. To place the accused on his defense in those circumstances has usually been said to be in conflict with the presumption of innocence. Close quotation.
Lapho kade qhathanisa phakathi kwelinye ke icala selahlalela ngaphansi kwenkosi enkantolo ke lapho ke lecala kade akhuluma ke ngalo ke lapho ke la Shopping futhi nabanye ke lapho ke kade hle lapho ke la M3 uthi judge yakhona ke lapho ke nkulumnkosi enkantolo ke lapho ke lathi khona ke egcineni kwecala noma qhathanisa phakathi kwesicelo sakhe lesi futhi nesicelo secala leli kade akhuluma ke ngalo ke qala.
In State versus Lubata 2001, Volume 2, SACR 703 SCA, the following was said. The right to be discharged at that stage of the trial does not necessarily arise, in my view, from consideration relating to the burden of proof or its concomitant, the presumption of innocence, or the right to silence, or the right not to testify, but arguably from the consideration that more general application. Clearly, a person ought not to be prosecuted in the absence of a minimum of evidence upon which he might be convicted, merely in the expectation that at some stage he might incriminate himself. That is recognized by the common law principles, that there should be a reasonable and probable cause to believe that the accused is guilty of an offense before a prosecution is initiated. See Beckenstrater versus Rota and Tiernesen, 1955, Volume 1, SA 129, capital letter A in bracket, at page 135, paragraph C to E. And the constitutional protection afforded to dignity and personal freedom in terms of Section 10 and 12 of the Constitution seems to reinforce it. It ought to follow that if the prosecution is not to be commenced without that minimum of evidence, so too should it is when the evidence finally falls below that threshold. That is preeminently to be so where the prosecution has exhausted the evidence and the conviction is no longer possible except by self-incrimination. A fair trial, in my view, will at that stage be stopped, for it threatens thereafter to infringe other constitutional rights protected by Section 10 and Section 12 of the Constitution. Close quotation.
Nalapho futhi uyaqhathanisa phakathi kwecala lapho ke likambuso futhi icala likalubaxa lapho icala la ngo-2001 ngaphansi usuthi volume 2 lapho ke CCR 703 lapho icala ka-inter ali lapho ke bayakhuluma phecelezi ngodaba lolu ke lesicelo sakhe sokuthi zena abasolo babadedeleke noma umsolo amdedeleke lapho ke bangamthwesa icala ngaphansi kuwonkana amacala ade bemthwesa wona ke lapho ke yilokhu nje kuphela kade kubalekile bekakhuluma ngakho uqhathanisa phakathi icala leliyana eselahlala ngaphambi kwenkosi enkantolo ngesikhathi esindlule futhi icala lakho lamanje.
It has been held that the credibility of state witnesses at this stage of the proceedings only play a very limited role. In State versus Impeta and others, 1983, Volume 4, SA 262, capital letter C at 265 D to G, Williamson J. held that relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it. Close quotation. Therefore, to summarize the legal position regarding application in terms of Section 174 is as follows. An accused person is entitled to be discharged at the close of the case for the prosecution if there is no possibility of a conviction other than if he enters the witness box and incriminates himself. B. Credibility of witnesses' evidence is only an issue where it has been the effect that the evidence is so unreliable that it can be said that no evidence has been adduced. C. Where the evidence of the state witnesses indicating the accused is of such poor quality that it cannot be relied on, and there is accordingly no credible evidence on record upon which a court acting carefully may convict, an application for a discharge should be granted. D. An acquittal must be in the interest of justice. E. Circumstantial evidence in the state case may be relevant factor in deciding whether a case against the accused is so strong that it calls for a reply in the witness stand. It is against this legal background that I find it prudent to refer to the portions of the evidence of Zungu in the record of the proceedings and later proceed to analyze his evidence. Constable Sizwe Sikumbuzo Zungu testified that he was a constable employed by the South African Police Services with 12 years experience under the invisible policing station at Sebenza Police Station. He knows all the accused before court. He knew Mthokoziseni accused number 4. He remembers him from Phosphorus, but not back home. On the 26th of October 2014, he received a call from Gwabeni. Gwabeni wanted to know from him, that is Zungu, whether he was able to come to Phosphorus on that day. He responded that it was still early because it was around 7:15, and that on that day he was still going to work. Gwabeni called him again and informed him that there was another brother of ours, Makosonke from Rustenburg. He informed him that Makosonke was also going to be joining us. He knocked off and contacted Makosonke Zungu. He informed him that he was at Johannesburg at Carlton Center. That is where he will find him. He went there and found him. They arrived at a hostel between 2 to 3. He will not be able to remember the exact time.
lapho ke kade afunda phecelezi nodaba lolu ke futhi washo khona njalo uma ibuka lapho icala lapho ke lezombuso kade lapho lihlelwe inkosi enkantolo lapho ke uHomuke lapho ke futhi icala lezombuso phakathi no Aglito la ngo 2011 volume 2 lapho ke CCR 437 lapho ke bayaqhuma phecelezi nodaba lolu ke lokuthi khona ke lapho ke uma ngabe icala seliphethe fika emaphethelweni ke lapho icala lezombuso ke lapho ke uma ngabe ke umswa lapho ke ngafisa ukwenza lokho kulandelayo ngaphansi kwezomthetho ke nakho ukuthi akwenzeke lo sicelo sesikhethekile lapho ke lathi khona ke umsola khona ke njalo ovumelekile futhi unakho ukwenza lokho ke egcineni kwecala lezombuso lapho ke ekuthizeni aqhamkise nesicelo sakhe lapho ke noma mhlambe eyabiza abofakazi bakhe ke lapho ke noma ngene ngaphakathi kwebhokisi lapho ke bese ayikhulumela noma mhlambe ke lapho ke asifake yena ke kumathupha ke ecaleni ke lapho ke athi lapho ke uma ngabe sibuka futhi bofakazi ade bekhona ke lapho ke uma bengenaso isihlahla mhlambe isihlahla msindo lapho ke kwamele ukuthi abasola lapho babadedele bababone futhi bengenacala lapho ke wathi kukhona uma sekubuka uma wathi lokho kukhona uma buka phaka icala lapho ke lekambuso futhi noSwarts lapho ke la ngo 1999 volume 1 lapho ke CCR 319 lapho ke kuthiwe open bracket besathi W lapho ke noma ukuthi lapho ufakazi bezombuso lapho ke namhlanje noma ufakazi noma abofakazi bezombuso lapho uma belethe ufakazi obungenasihlahla msindo noma ubufakazi lapho mhlambi ke obungahambisani ke lapho ke noma ufakazi lapho ke mhlambi ubuphuwa ke lapho ke obungenayo ke lapho ke isihlahla msindo kubonayo ke lapho kufazi obomelana nalokhu naloludaba loluke athi kwamele inkosi inkantolo lapho ke ingagwebiki abaso engasolwa noma engabathuli-ke abasolwa benicala lapho-ke kwamele futhi ekuthizeni ibavumele uma ngabe sebeletha isicelo sabo sokuthi babadedele ngaphansi kwamacala wonke akade bebathusa wona-ke lapho-ke bathi ku-D lapho-ke usho ukuthi lapho lokhu kumele ukuthi bakwenze ngaphansi kwezomthetho noma ngaphansi kwezamalungelo ezomthetho-ke lapho-ke futhi wabuya wathi washo khona njalo-ke lapho-ke wathi mina nofakazi bethimba lwezombuso loba abathi bona-ke banabo lapho-ke kwamele ukuthi inkosi enkantolo futhi ibukisise futhi ibuke ngendlela ekhethekile futhi ngendlela-ke ejwayelekile engabuke ngendlela engajwayelekanga ngabofakazi lapho-ke kade bekhona-ke lapho-ke bese qhathanisa phakathi kwecala lezombuso-ke lapho-ke nocele lango-1986 volume 2 PHH 121 futhi washo khona njalo lapho-ke uma ngase sikwapha ku-background-ke lapho-ke sithi abofakazi kade bekhona-ke lapho-ke bathi khona-ke ufakazi othizeni-ke lapho-ke okade bekhona ufakazi bakhe okade ekhona ngaphambi kwesenkantolo-ke lapho-ke bese washicelela ufakazi bakhe lapho-ke bathi uzungu bathi khona kwento ekhuluma ngaphakathi kwenkosi enkantolo-ke ngesikhathi bekalana-ke washo khona njalo yena-ke uconstable Sizwe Sikhumbuzo Zungu-ke lapho-ke ngesikhathi bekathula ufakazi bakhe-ke lapho-ke washo uconstable futhi usebenza ngaphansi kwezesiphoyisa-ke wathi uneminyaka-ke eyi-12-ke sipiliyoni esebenza ngaphansi kwezesiphoyisa-ke futhi usebenza ngaphansi kwezesiphoyisa sasebenza police station-ke lapho-ke futhi washo yena ukuthi bonkana abasolwa uyabazi laba bekhona ngaphambi kwenkosi enkantolo-ke futhi wathina uMthokoziseni wamazi njengomsolwa wesine-ke lapho-ke ngesikhathi bekaqala kumbona lapho eFosforasi-ke kepha kanawo umkhumbulo wakhe wasemakhaya-ke athi ngelanga lenge-26 October nyaka 2014 yena kwathola ucingo kade liqhamuka koGwabeni bathi uGwabeni uyena-ke owazisa-ke uzungu noma watshala-ke uzungu okuwukuthi kwamele ukuthi afike eFosforasi ngalo-ke lela langa lelo-ke bese uzungu waphendula wathi yena-ke wabamshayela ngesikhathi sakusasa samahora kusasa-ke athi nge-7 yakusasa-ke lapho-ke yena futhi bekazokuselela kuya emsebenzini ngesikhathi bekashayela lapho-ke bathi uGwabeni-ke nawe uyena-ke wamtshela khona njalo ukuthi khona-ke omunye umfowabo-ke lapho-ke noma umfowabo lapho-ke kade kwabathi uMakhosonke-ke maqhamuka ngaphansi noma kade aqhamuka-ke Rustenburg-ke uMakhosonke lapho-ke bathi wamtshela ukuthi uMakhosonke khona-ke na futhi uzofika abajoyineke noma hlanganele nabo endaweni eyodwana-ke lapho-ke bathi yena-ke washayisa-ke emsebenzini ngesikhathi beshayisa emsebenzini-ke bese waqwathinta-ke uMakhosonke-ke lezungu-ke lapho-ke wamtshela ukuthi kumele bahlangane lapho-ke eGoli eduze nase-Carton Center noma e-Carton Center-ke lapho-ke athi yona ndawo bekazomfica kuyo ngeleyo-ke uma ngabe sekashayisile emsebenzini-ke athi empeleni ngangeqiniso ogcina befika-ke lapho-ke hostele ngemuva kwehora lesibili noma ngehora lesithathu kade engasakhumbuli kahlehle ukuthi ngabe wafika ngasiphi-ke isikhathi lapho-ke.
It is against this background that I will proceed and analyze Zungu's evidence. According to the version of the state, the only witness who met and placed the accused at Phosphorus Hostel on the 26th of October 2014 was Constable Zungu, Constable Sizwe Sikhumbuzo Zungu, who was a single witness. It is straight law that a court should approach the evidence of a single witness with caution. The following passage from the judgment of the Phyllis J.P. in R. vs. Mokoena 1932 OPD 79 at page 80 is frequently cited. I quote, "The uncorroborated evidence of a single competent and credible witness is no doubt declared to be sufficient for a conviction. But Section 284 of Act 31 of 1917, that is the predecessor to Section to the Act 51 of 1977. But in my opinion, that section should only be relied on where the evidence of a single witness is clear and satisfactory in all material respect." Close quotation. In State vs. Weber, 1971, Volume 3, SA 754, capital letter A in bracket, the Appellate Division stressed that there was no magic formula which determines when the evidence of a single witness testimony may warrant a conviction in every case. What may be said, however, is that the evidence of a single witness has to be approached with caution. His or her merits as a witness must be weighed against factors which militate against his or her credibility. Thus, the mere fact that he or she has an interest or bias against the accused will not of itself obviate a conviction. It is necessary to assess the intensity of the bias in the light of the totality of the evidence. Close quotation.
Lapho futhi nodaba lofakazi oyedwa-ke suthi ufakazi kodwa mhlawumbe suthi ithimba lezombuso suthi abahambisana nofakazi babo-ke futhi ibona-ke uyena ufakazi oyedwana kuphela lona-ke kade ubeka-ke abasolwa ngaphansi kwendawo sephosphorus lapho-ke wathi ufakazi lo-ke uConstable Sizwe Sikhumbuzo Zungu-ke owasukela ukuthi mina-ke kade likhona-ke lapho-ke lokuzana lapho-ke ethuba-ke futhi obuye washo khona ukuthi ithimba lezombuso futhi nenkantolo-ke lapho-ke akumele ukuthi lapho-ke uma sebuka kufakazi babuke kufakazi bofakazi oyedwa-ke osho ukuthi ufakazi oyedwa-ke loyo-ke osuke esikhathini esiningi-ke ebeka-ke labantu abasolwa-ke ngaphansi kwendawo yesigameko-ke noma ngaphansi kwendawo ekhethekile noma ngaphansi kwendawo ethizeni-ke lapho-ke ngoba bathi lokho mhlawumbe esikhathini esiningi usuke akwenza ngokuthi na-ke mhlawumbe unento-ke mhlawumbe susho ukuthi mhlawumbe angayithandile kubona mhlawumbe engahambisani-ke nabo-ke noma mhlawumbe eyenza lokhu ekwenza lokhu-ke ngokuthi ufuna ukuthi abantu abasuthi mhlawumbe abacekela phansi-ke lapho-ke noma futhi bababone-ke benecala-ke abantu labo-ke bathi inkosi enkantolo kwamele ukuthi lokhu kubuke futhi ngendlela-ke ekhethekile futhi nangendlela-ke ejulile.
Corroboration. In State vs. Gently 2005 Volume 1 in bracket SACR 420 at 430, Clute JA in dealing with the approach to be followed by a court when it is faced with a situation where a court should caution itself in analyzing the evidence said the following, I quote, "It must be emphasized immediately that by corroboration is meant other evidence which support the evidence of the complainant and which renders the evidence of the accused less probable on the issue in dispute," close quotation. It is clear from the authorities that if corroboration was required, if it had, for purposes of the so-called cautionary rule, to be corroboration implicating the accused, and not merely corroboration in the material respect or respects. The evidence of Zungu was not corroborated in all material respects. Sikhumbuzo Zungu was not called by the state to corroborate the version of Zungu, insofar as traveling with Zungu to the hostel after he had received a call from Gwabeni to pick up Sikhumbuzo Zungu at Carlton Center in Johannesburg. Zungu is the only witness who met the accused at Phosphorus Hostel. He was introduced to the accused by Gwabeni. It is surprising that this introduction was done to this witness when Zungu and the accused knew each other. Zungu testified that he was requested by a certain gentleman, that is accused number 5, was requesting him to remove his vehicle because he had parked behind the vehicle that accused number 5 was traveling. Zungu and others he was seated with went to buy liquor and they drove using an Uno motor vehicle. He was traveling with accused 2, accused 3, and the driver. There were 5 in total. From the body of Zungu's evidence, this is the only time that he had traveled with accused 2 and accused number 3.
Lapho futhi bekade afunda khona-ke phansi but nofakazi lokho kade buhambisana-ke lapho-ke athi lokho sibuka ngaphansi uma eqhathanisa kumacala-ke lapho-ke icala lapho-ke lezombuso-ke libhekene icala lapho lika-Gently 2005-ke lapho-ke volume 1 SACR 420-ke lapho-ke futhi ngaphansi ko-430-ke lapho-ke futhi inkosi enkantolo lapho kade kuwuClude JA lapho-ke athi ngesikhathi kade kusenzeka lokhu-ke ushuthi noma eqhathanisa-ke lapho-ke athi inkosi inkantolo kwamele lokho ikubukisise ngendlela eqondile futhi ngendlela ekhethekile-ke lobu lofakazi obulandelayo-ke noma mhlawumbe ubufakazi obulandelayo labo-ke labo khona-ke kwamele ukuthi lokho bakwenze benze iqinisekiso ubufakazi labo buyahambisana bonkana futhi bonkana nofakazi babantu ade bevula icala lapho-ke beyahambisana nofakazi bonkana babofakazi esube bezolothwa ngaphambi kwenkosi enkantolo lapho-ke besathi ummeli lapho-ke uma eseyafuke lapho ku-14.2 lapho-ke athi cace bha ukuthi lapho-ke lokhu akaze kwenziwe-ke lapho-ke noma kade akwenziwe ngendlela ekhethekile lapho-ke ngoma uma sekhona lapho nge-cautionary rule-ke lapho-ke somthetho okhethekile lapho-ke ubufakazi ushuthi lapho obuquka khona-ke abasola bonkana noma bafaka ngaphathi abasola bonkana-ke lapho-ke bathi lapho-ke ufakazi oyedwa lapho uZungu-ke wena ufakazi bakhe futhi nabo-ke akade bungahambisani ngaso sonke-ke isikhathi lapho-ke ngoba mayelana nenkulumo yakhe-ke uZungu yena-ke into ayikhuluma kuwukuthi yena-ke kade ehamba-ke lapho-ke noZungu ngaphakathi kwemoto ngesikhathi besiya lapho-ke elokozana kule ndawo kade beya kuyona. Ngemuva ukuthi athole ucingo uqhamuke kugwabeni emcela ukuthi akahambe ayodobha ulokozana omunye kuzungu lapho ke-carton center yakhe eceliwe lapho kusikhumbuzo zungu-ke yena-ke egoli-ke. Athi uzungu ngesikhathi ade kusenzeka lokhu-ke futhi wafika-ke ehostele swahlangana nabo-ke abasolwa-ke lapho-ke. Athi ngesikhathi bahlangana nabasolwa-ke ehostele-ke lapho-ke athi uyena-ke ugwabeni owamazisa-ke kubona-ke abasolwa-ke lapho-ke noma lolo hlelo uthi libona-ke bazane-ke lapho-ke bathi lo hlelo lwenziwa-ke lapho ugwabeni-ke. Ngemuva ukuthi kwenziwa lokho-ke bathi uzungu obuye futhi wakhuluma khona njalo-ke lapho-ke. Athi khona-ke lapho-ke umuntu wakhuluma naye lapho-ke umsola wesihlanu-ke lapho-ke ngesikhathi ade emcitha akasuse-ke imoto yakhe ngemuva kwemoto yakhe-ke lakade imise khona-ke ngoba uzungu imoto kade ahamba ngayo kade ime ngemuva kwalapho-ke noma umsola wesihlanu umuntu kade ehamba ngayo kade ime lapho-ke nayo-ke futhi. Bathi uzungu futhi nabanye-ke lapho kade behlezi lapho-ke phansi bezijabulela-ke lapho ke bese bahamba beyothenga-ke lapho-ke iphuzo-ke zokudakwa-ke lapho-ke bahamba basebenzisa-ke imoto kade kuyi-uno lapho i-uno imoto kade besebenzisa lapho kade behamba lapho-ke futhi bathi ngesikhathi kade behamba kade khona kumsolo wesibili umsolo wesithathu nomshayeli futhi ngesikhathi behamba bonke kashuthi kade bebahlanu ngaphakathi kwaleya moto ngesikhathi lesi beshayela behamba ngayo-ke lapho-ke. Bathi uzungu yena-ke lapho-ke yena-ke wakhuluma njalo ukuthi yena-ke umuntu wahamba naye kumsolo wesibili futhi nomsolo wesithathu.
In his affidavit dated the 23rd of May 2023, which was obtained some 4 years later after Brigadier had taken over this investigation, page 2, paragraph 4, line 10 to 11, Zungu states the following, and I quote, I must also state at some point, I also at some point went out to the shops to buy some alcohol or drinks with a certain lady and came back to Gwabeni's house. Close quotation. It is clear that Zungu does not place the accused, that is accused number 4, traveling together using the VW Polo hatchback grey in color that he alleged accused number 5 was using, leaving the hostel, and part of his evidence is that he saw accused 1, 2, and 3 following each other, going towards Gwabeni's room, and he followed them. Inside the room, accused 1 was in possession of a .38 special revolver, and accused number 3 was in possession of a 9mm pistol. Accused 5 came inside the room. He was followed by accused number 4. Zungu states the following at page 2, paragraph 5, line 1 to 3 of his affidavit, and I quote, around 9 p.m. on the very same day, I noticed Moses Spear Mafiga, open bracket, Sandy Sontanzi, close bracket, and Kani, open brackets, Fisogutle Zungu Ntuli, close bracket, walking after each other to Gwabeni's bedroom from outside. It does not mention accused number 4, following accused number 5 to Gwabeni's room. At page 2 of his affidavit, paragraph 5, line 6 to 9, he states the following, and I quote, I saw Moses giving Gwabeni a .88 special firearm and Kani giving Gwabeni a 9mm firearm, close quotation. At page 2 of his affidavit, paragraph 5, line 20 to 21, he states the following, and I quote, Mthokoziseni Mapisa and Carlos Mncube walked into the bedroom and sat on the bed, close quotation. There are material contradictions between Zungu's evidence in chief and his written statement. The correct approach to any contradiction between the prior statement and the witness's testimony was, in respect, most useful, summarized by Olifield J.A. Instead versus Mafada Diso in another, 2003, Volume 1, SACR 583 SCA. The head notes in that case is submitted accurately, reflected, was said and was cited by Nechben J. Instead versus Governor, and another 2006, Volume 1, SACR 322, capital letter E in bracket. In respect of the factual evidence of Zungu's evidence, the contradictions are material and affect his credibility. During cross-examination by Mr. Ramsepel in respect of Zungu knowing accused 2, this is how Zungu responded, and I quote, Mr. Ramsepel. Now, accused number 2, because I will chop and change with respect to accused 1 and 2, but accused 2 himself says he does not know you in total. He just see you here yesterday in court, Mr. Zungu. If that was said or was coming from accused 3, 4, and 5, I would have agreed with you. Okay, where I was born or back home, where I was born, or he is Ndanzi. It is clear from Mr. Zungu's evidence, when question is posed to him by Mr. Ramsepele in respect of him knowing accused number 2, his response was that if that was said by accused 3, 4, and 5, that they do not know him in total, he was going to agree. The response by Zungu is a clear indication that he did not know accused 4, in the light of the fact that he says he was going to admit that he did not know accused 4 if such assertion was put to him by accused number 4. During cross-examination, Zungu testified that a typed version of his statement was made out of notes that he had written himself. And where there are contradictions in paragraph 5, he actually meant accused 4 and 5 entered Gwabeni's room and not accused 3. During cross-examination by Mr. Ramsepele about Zungu mentioning in his written statement that he went to Top Spa to buy liquor in the company of a lady, this is how Zungu responded. Mr. Zungu, I think maybe it is a manner in which it is put here, but I did go to Tops with the gentleman. We came back and then there is a lady that just want to go nearby, who had requested me to buy her a drink, and I did go out with that lady. In his evidence in chief, Zungu testified that the person wearing a cap was accused number 2 when he was confronted that in fact the person wearing a cap was accused number 4. He could not proffer any explanation. Zungu testified that at some point he met Brigadier Lishabane, who informed him that he was going to conduct his own investigations and thereafter he would come back and inform him, but did not tell General Lishabane that he was at the hostel. The reason was that he did not want to give General Lishabane this information, that it was coming from him and that he did not have certainty with regard to that. Clearly, Zungu had an axe to grind for the accused when one considers the compactness of his evidence. Zungu testified further that on the 13th of November 2013, he had a meeting with Brigadier Gininda. Brigadier Gininda asked him what he knew about the killing of Senzo Meyiwa. He told Brigadier that he knew nothing and there was nothing that he can talk about. Brigadier Gininda told him that he was going to do his own investigations. At that meeting, Brigadier Gininda was with Brigadier Tony. Zungu testified that the relatives of accused number 1 wanted to shoot him. He spoke to accused number 1 over the phone and asked accused number 1 why his relative wanted to shoot him, because he, Zungu, also did not know anything about this matter and did not know anything. It is clear, my lord, that from the responses or the evidence of Zungu, he mentions that not even on one occasion that he did not know anything about this case. He said this in the presence of General Lishabane. And on the 13th of November, when he had a meeting with Brigadier Gininda, he repeated the very same assertions that he did not know anything or knew nothing about the killing of the deceased. Thirdly, he mentioned this when he spoke, as he said, to accused number 1, when he was making inquiries about why his relative wanted to kill him, because he did not know anything about this case. Further, to proceed, Zungu could not explain what was the occasion. On page I'll come back to that. Of Exhibit C, despite claiming that he was with accused 3 and 4 on the day of that occasion, the date of the 26th of October, 2014.
But you're saying Zumu's evidence is not corroborated in any of the evidence led in this court?
Yes,
Never.
never.
Remember, what's the time this is?
It's 11, getting a lot.
Yeah. Well, you remember there was evidence by Buthelezi, a gentleman called Buthelezi, who went to see accused number 1 to give him some washing items. Sorry, number 2, yeah, you're right. In Rustenburg, next to some supermarket there.
Yes, I remember that evidence, my lord, very well.
Yeah. And then there's another piece of evidence. I don't know if it's accused number 1, who was drinking Irish whiskey and exclaimed that Senzo is no more. Senzo is no more. You don't remember that?
I remember.